what people also need to understand is that typically the law firms that are bringing these suits are crowdfunded through charities. There's not a lot of private action that is taking place in Alberta. There's a couple bits and pieces, but frankly, this is a real David and Goliath battle. And for small firm lawyers to mobilize against the government and unlimited resources, and also to try to get the court to move quickly when the courts never really move quickly, especially during a time where, there's arguably some administrative issues relating to the pandemic. It's a real struggle.
If you want to help us stand up in the courts against these illegal and unconstitutional violations of our fundamental rights, you can do so by signing our petition and contributing at fightvaccinepassports.com.
Any donation you make goes to the Democracy Fund, a registered Canadian charity, so you will be helping in the fight for freedom, and you'll receive a tax receipt.
Warning, censorship.
Adam Sos here for Rebel News, and in just a moment I'm going to be joined by Chad Williamson of Williamson Law. He is one of the lawyers that is being provided to folks who are fighting for their fundamental freedoms at no cost to them, thanks to your generosity at fightvaccinepassports.com. Chad, thanks for joining me. I wanted you to give us a little bit of an update about the latest work. We're doing so much great work across this country. You yourself are working on a number of cases, but what's the latest efforts on the front of Fight Vaccine Passports?
The biggest initiative that we've undertaken in the last couple of weeks is to file what we call an Omnibus challenge, constitutional challenge of the Restriction Exemption Program, which is more commonly known as the vaccine passport.
That is why the government has reluctantly decided to adopt the Restriction Exemption Program, a proof of vaccination program for participation in certain discretionary activities that have a higher risk of viral transmission.
In Alberta. And we've challenged this on a number of constitutional grounds, but we're also challenging some peculiar protest legislation that has been rejigged to prevent people from protesting and exercising their freedom of expression at hospitals. So it's kind of a robust package that we've put a lot into, and it's a pretty serious claim, and it follows along the lines of some of the other previous constitutional challenges that we've filed in the past and continue to work on.
Of course, all Canadians have the right to protest peacefully. But using our hospitals as a venue to attack vaccines and reasonable public health measures only adds more stress to our already overburdened frontline workers.
And there are a few names as far as the applicants who are listed on this lawsuit, the people who are named as sort of providing this legal action against the province. Can you tell me a little bit about their stories?
So there's three named applicants. There's Amanda Robinson, and Amanda is a young gal who has suffered some discrimination as a result of a medical condition which would prevent her from getting the vaccine. But also, and most interestingly, she's also got a religious exemption as well, which kind of gives her a two-pronged approach to challenge on constitutional grounds the vaccine passport and how those have negatively impacted her. We've also got a fellow by the name of Joseph Kenny, who's he's a great guy, a true Albertan, and he's just a fellow that is discontent with the current state of affairs in Alberta and wants to exercise his right to protest as he's been doing, and has been the right that he has to protest has been significantly limited by the a piece of legislation called the Critical Infrastructure Defense Act and its regulations, which have now been rejigged from just prohibiting protesting at pipelines and critical infrastructure to now also be prohibiting people from protesting at hospitals. We also have a fellow by the name of Joseph Rylance, who strictly has a religious exemption for taking the vaccine. It just doesn't align with his spiritual and religious beliefs. beliefs which are enumerated in protected grounds under the Constitution, as well as various Bill of Rights pieces of legislation that protect those rights.
So a number of people representing, likely on the broader spectrum, thousands who are in very similar situations, perhaps for medical reasons, religious reasons, or other reasons. They feel that their fundamental rights have been infringed or affected negatively in some way. Also named in the suit are Jane and John Doe. Is that correct?
Yeah, so likewise, this is what we kind of see as a reciprocation of some of the actions that the government of Alberta has brought against Albertans en masse by naming John Does and Jane Does. In reciprocation and for strategic purposes, we've left the grounds open for other applicants to potentially join this action. So there may be additional applicants in the future. At the end of the day, we do want to make sure that we've got the most solid framework with which we can kind of bring this action. So the applicants that we've chosen, we feel, really represent the broad spectrum of Albertans whose rights have been so adversely affected by some of what we consider to be the unconstitutional actions of the Alberta government and Alberta Health Services.
And so what are the actual legal grounds for which what the government of Alberta has done is wrong? And what are the legal grounds on which you're challenging them?
So the primary thrust is, of course, the charter arguments, and this would be freedom of expression, freedom of religion that are enshrined in Section 2 of the charter, as well as Section 7, which is a person's right to life, liberty, and security of the person, and also importantly, Section 15, which is the right to be equal under the law and not be discriminated against because of a physical disability, a mental disability, or because of your religion. And of course, there's a whole bunch of other stuff under that section that may or may not necessarily apply. But we feel that the current exemption program really restricts people from even partaking in society by no fault of their own on account of perhaps their religious beliefs or because of some medical condition, which is obviously not a conscious choice.
Well, it's great to hear that we will be going to court thanks to people's generosity at fightvaccinepassports.com. I wanted to get into sort of a broader question, perhaps not relating exactly to this case, but there is a bit of a sentiment out there, at least me not being a lawyer looking at it, that there has been at least to some extent a delay in reviewing some things, or there are very few judges who are addressing all these cases. We see the same names coming up. This notion of justice delayed is justice denied. Could you comment on that a little bit?
And we're fairly frustrated with what has been happening with the court process, and it's a very dynamic and complex situation that is, of course, causing some of these delays. One of the main reasons why there have been so many delays is the courts like to case manage for efficiency reasons and for budget reasons. They like to case manage bulks of cases, and they like to try to pick one essentially upon which they can render a decision that will hopefully try to capture some of the nuances and elements of the other cases that are before the court. And there have been, to my knowledge, dozens of constitutional challenges of varying types that have been launched in response to the government's reaction to the pandemic, whether that was closing down restaurants or businesses, or whether that was implementing what we see as an unconstitutional vaccine passport program. And frankly, the courts have basically said, hey, look, we're going to pick one case. This is going to, we're going to render a decision that will hopefully touch on all these areas so we can kind of wrap these all up with a bow. The biggest issue is that all of the other cases have essentially been held in abeyance until this case that they've selected has gone ahead. And of course, it continues to be adjourned, and it's now scheduled to be heard in February, which obviously causes problems when we've got such a fluid and ambulatory situation like the pandemic with, ever-changing and ever more aggressive restrictions that are foisted upon the population. And of course, the courts are also having a difficult time dealing with just the sheer number of these cases that have been basically filed.
So the question that I would have then is, in the meantime, people's rights are being pretty evidently trampled upon. Why is there no sort of metric where the judges say, well, you can't implement all these restrictions until you've defended them in court? We've seen Dr. Deena Hinshaw say she's far too busy to be held accountable and then go on vacation. Just from an outside spectator, it seems like if they're not willing to show up in court and justify the violation of these rights, that their measures should be held off until court, or until it's heard in court.
So the blame for the delay is, I mean, it's really on all of the parties and not necessarily just on the government. These are enormously complex cases. In the foundational case that's proceeding in February, there's actually, I think, almost a dozen medical experts on both sides that are scheduled to give evidence. And whether or not, the justification for, the fourth wave and me not necessarily being available to give evidence is truthful or valid, it's just one of the many factors that are delaying the hearing of these cases. And there's also schedules of judges, schedules of lawyers, the bulk of the cases, the availability of the experts. So it really is a complex matter. And I know that that's not really solace to the people whose rights are being violated and who are waiting for these matters to be heard. Mm-hmm. But they are being also case managed by the judiciary as well. And whether or not they're doing this in an efficient way, I mean, frankly, it's their discretion, and we don't always agree with necessarily some of the procedural decisions that have been made. And in fact, we've actually challenged a couple of the procedural decisions. We challenged one going all the way up to the Court of Appeal, and our application to appeal that decision was denied, which has essentially given the lower court judges the authority to apply their discretion in ways to, hopefully help the economy and the efficiency of this stuff. Whether or not that's happening, obviously, is a matter of debate. And we're not always happy with the decisions that are coming down from some of these courts in that respect.
So it might not be unreasonable for someone to suggest, not you by any metric, but if someone were to view this as an intentional effort to delay this while the government sort of maintains what they're doing so that it's not questioned, would that be potentially, not to put those words in your mouth, a reasonable conclusion someone could draw?
I mean, there are elements of delay, I'll say, on all sides, and this is problematic. And I mean, to be fair to everybody involved, especially the applicants and the lawyers for these applicants that are bringing these actions, what people also need to understand is that typically the law firms that are bringing these suits are crowdfunded through charities. There's not a lot of private action that is taking place in Alberta. There's a couple bits and pieces, but frankly, this is a real David and Goliath battle. And for small firm lawyers to mobilize against the government and unlimited resources, and also to try to get the court to move quickly when the courts never really move quickly, especially during a time where, there's arguably some administrative issues relating to the pandemic. It's a real struggle. And like I said, we don't always agree with the way that things, kind of unfold. But if you add the complexity, if you add delay tactics from all sides, strategic decisions that are made, again, these are tremendously complex cases. And I know that it doesn't give people, a degree of relief that this is going to be heard fast. Mm-hmm. One thing I can say is that when you bring these types of actions, they need to be brought properly. Mm-hmm. One of the biggest mistakes that a lawyer can make is to bring an application that's doomed to failure, because it can set negative precedent that will be relied upon in the future. And so a lot of these cases, there needs to be a lot of legwork that goes into them. And then again, if you face delay tactics from the other side, which is common in all types of litigation, especially when someone's responding to a large omnibus action, it results in serious delays. And it's a huge problem, and it does prevent access to justice.
I want to thank Chad for that important update and for giving us a bit of a update on the general situation and the legal battles against vaccine passports in this province. We'll be sure to touch base with him as these cases progress so that we can keep you posted on the important work we're doing with your generous contributions at fightvaccinepassports.com. As always, I want to thank you for tuning in. For Rebel News, I'm Adam Sose. You heard it from Chad yourself. We are absolutely counting on you to wage these legal battles against vaccine passports. If you want to help us stand up in the courts against these illegal and unconstitutional violations of our fundamental rights, you can do so by signing our petition and contributing at fightvaccinepassports.com.
Any donation you make goes to the Democracy Fund, a registered Canadian charity, so you will be helping in the fight for freedom and you'll receive a tax receipt.